All right, looks like we have everybody connected. So we'll go on the record in Crowderfield versus Crowderfield. This is case number 2319399. It looks like we got both parties present here. This is set for a status conference today. And Mr. Crowderfield, are you able to hear me okay? I'm going to need you to unmute yourself.
Okay, yes, I can hear you.
Okay, and Miss Crowderfield, are you able to hear me?
Yes.
Okay. All right. So it's been a while since you guys have been in court here. I believe at the last hearing, you both indicated that there were no issues regarding the division of any assets or debts. And so this was set for a final hearing today. However, I don't have the final documents that we need to finalize your divorce. That's a judgment of divorce and a final child support order. So Mr. Crowderfield, I mean, aside from getting all the documents together, are there any issues that need to be resolved, or are we ready to finalize things?
Well, as far as that child support goes, the reason I did not turn that paperwork in, I had taken it to front of the court to make sure I had gotten everything filled out correctly. They said I did, and then a couple spots that I missed, and they had helped me, figure out what to do with it. And I had mailed it to Haley. She had mailed it back, and when I got it back, there was things on that form that I did not do. She'd scribbled my name out in a place and wrote her name. She had check marked a box that I did not check mark. And from what I was told from front of the court was that all she had to do was just either sign it if she agreed and send it back, or not sign it if she did not agree, and that's fine. So
Okay.
I didn't want to turn that in with those changes because I mean, all she had to do was either sign and not sign. So I didn't know how to go about that. And I went to front of the court to try to talk to them a little bit about it. And they couldn't really help me out as far as what I needed. But that's why I did not turn that form in.
Okay. How about in terms of the assets or debts of the marriage? Is there any issues relating to that, or have you guys agreed on all of those things?
Nope, there's no issues there. We've agreed on everything.
Okay. All right. Ms. Crowderfield, are you able to hear me okay?
Oh, hello? It keeps kicking me out of the meeting for some reason.
Yeah, I'm not sure. I see that your camera's going in and out. Where are you at with things? Are we ready to finalize this divorce, or what concerns do you have?
Other than the paperwork he sent in, because it was basically saying that he would get full visitation with my daughter, which our child custody order was already in place, so that would completely void that. But yeah, when it comes to the divorce aspect of it, yes, I agree with everything.
All right, so what I have here is regarding custody is that you guys are going to share joint legal and physical custody with basically, week on, week off parenting time. So you guys are both going to essentially be sharing 50-50. Is that right?
Yeah, I don't know if he has the paperwork in front of him, if he can read where I made the amendment, so maybe we can both understand more what that means.
Yeah, I don't know. I don't have that in the file, Mr. Crowderfield. Do you have that?
It's on the parenting time, page 2, number 7. It says it is further ordered that, and then blank. So I wrote my name, and that's where she crossed my name out, wrote hers. I didn't I'm not thinking that that was trying to give me full time or her. I'm just doing what my paperwork had me write. Um, so there's obviously some confusion on both ends, what it sounds like on this, because we both had agreed and we both want 50-50 equal parenting time with our daughter.
Okay. And when I'm looking at the child support recommendation from front of the court, that's what it reflects. It's 50-50 equal overnights of 182 and a half each.
Yes.
So, and I don't know what is the form that you're looking at, Mr. Crowderfield? What does it say at the top?
Uh,
What's the title?
this is the state of Michigan, the 46th Circuit Court Family Division. The judgment
Okay.
of divorce is the one that I got.
Okay, all right, got it. Okay, so yeah, that's the correct form, and we definitely need that form to finalize things. And that form should say shared joint and physical custody with 50-50 with both of you. So yeah, if
Yeah.
it says that you have sole custody or something, then that would be something that would need to be corrected.
Okay, so then on this page where we're both pretty confused on, I guess I'm just confused as to whose name really should go under the parenting time. Says it further ordered that blank shall have the right to reasonable parenting time with the minor child of the parties pursuant to the attached default standard or default long distance parenting time schedule inclusive of the designated number of overnights identified in the schedules unless otherwise hereinafter provided. So I guess that just kind of, I guess I think we're both a little confused on that. I don't
Sure, I
know
understand. It just needs to say, you just need to write in that you're both to have equal number of overnights.
okay.
Mm-hmm.
And then on the page before that, where there's a space, it says legal custody and physical custody, it should just say joint for each of those two.
Yep, I got that.
Okay. All right, so Mr. Crowderfield, if you can just make that correction, and then I'm gonna need you to check in with friend of the court again, and then Ms. Kraus, if we can get a final support order reflecting, the custody arrangement, so that Mr. Crowderfield can get that along with the judgment of divorce to the court before the next hearing, and then we can finalize things.
Yes, that'll
Okay.
be fine. I will be available after 11:30 today.
Okay. All right. So Mr. Crowderfield, do you feel like you are clear now? Does this clear things up?
For that, yes.
Okay. Are there any other issues?
Not really an issue. It just so we can kind of get on the same page. Haley and I had made an agreement as far as claiming our daughter on taxes. Just she claims on the even years for the odd years, and then I am vice versa. I was just wondering, as far as the child care goes, I tried claiming half of that and it wouldn't let me. So it said that it didn't say she had, it said somebody had already claimed her child care. So I'm just wondering for like next year, how is that going to work? Am I going to claim full claim for the child care even though Haley paid half? Or how is that going to work?
Yeah, I really have no idea on that. That's something that the two of you would need to discuss and work out between the two of you.
Okay, I was just wondering I didn't know how that worked. So
Yeah, I think that's something that you and Ms. Crowderfield would have to figure out together.
okay. Awesome.
Okay, Ms. Crowderfield, did you have any other questions?
Nope, that's it. Now that that's cleared up.
Okay, so Mr. Crowderfield, if you can check in with friend of the court and then get those documents to the court for the next hearing. And at that next hearing, I'll be able to take the testimony I need to take from each of you, and then we can finalize the divorce on that date. And the court will send you both notice of the date and time of that hearing, and it'll be by Zoom, just like we're doing today, okay?
Okay.
Okay.
All right, sounds good, thank you, and you're both free to disconnect at this time.
Thank you.
All right, whoever's on the iPhone, can you tell me your name, please, sir?
Uh, Talking to me,
Yes.
Jamar Freeman.
All right, thank you. All right, and Mr. Rolla, are you able to hear me okay?
Yes, Judge. Can you hear me?
I can, thank you. And then Ms. Stubble was, she was signed in for a second there. It looks like she got disconnected. So if everybody could just hold for a minute, we'll see if she reconnects.
Very good. Thank you.
All right, Ms. Stubble, I'm gonna need you to unmute, please.
Right there.
All right, ma'am, are you able to hear me?
Yes.
Okay, are you Veronica Stubble?
Yes, sir.
Okay, we're on the record now in Stubble versus Freeman. This is case number 23-19526-DP. We have both parties present by Zoom video. Mr. Rolla is present on behalf of the state today. This is the date and time set for entry of a judgment affiliation. And I do have that judgment's been submitted. Mr. Rolla, was there anything that you wanted to say in support of that today?
Yes, thank you, Your Honor. Although I don't believe Mr. Freeman signed the copy of the judgment, he did sign the response to the complaint that was filed from the court. In fact, we have a copy of it in our file. November 28th of last year, Judge. And pursuant to the legal memorandum I previously filed with the court, as the court's well aware, that response is sufficient even if we had to proceed, for example, with a default. We'd ask the court to make some initial, some preliminary inquiry and then enter the judgment.
All right. Ms. Stauble, this involves a child, Braylon Lee Stauble. Is that your biological child?
Yes.
All right, and this proposed judgment would provide that you were to have sole physical custody of Braylon, that you would share joint legal custody of the child with Mr. Freeman, and that he would have parenting time as the two of you agree. This would also provide for payment of child support by Mr. Freeman for the minor child. Is that your understanding?
Yes.
And as the mother of that child, are you asking the court to sign those orders providing for those things today?
Yes.
All right, Mr. Freeman, back in November, you signed a document and submitted that to the prosecutor's office indicating that you were the father of Braylon. Is that correct?
I guess so. That's what it was, yeah.
Okay, are you contesting that at this point?
At first, I don't know who it was that I talked to. Like, it was talking about a DNA test or whatever. And then at first I told her that I didn't want the DNA test. And then I started to think like, yeah, I wanted it. And then from the information that she gave me, I thought it was that when I signed the paper or whatever, and then I get a DNA test. But I guess I might be something wrong. I don't know.
All right, Mr. Rolla, again, what did you receive from Mr. Freeman?
Moment, please, Judge.
Okay.
Thank you, Judge. For the record, this is a letter that was dated from our office, November 1st, 2023, sent to Jamar Freeman, JAMARREEMAN, at 101 Christian Court, Rincon, Georgia, 31326, regarding this particular matter, advising him that we are preparing an establishment of paternity case, that if he requested testing, he was provisions he would have to do follow through to do that. And also there was a complaint that was attached to this, and it indicates to either answer the complaint at the bottom of this letter and return it to us in the enclosed envelope within 21 days. He signed it at the bottom with his signature purporting to be Jamar Freeman, and it was returned to our office on November 28th. So he acknowledged receipt of the complaint. He did not make a demand for genetic testing. He merely responded that he received the complaint, which, as I said to the court, and as we've previously provided, as our appellate courts have determined, his receipt of the complaint and acknowledgement, and then not demanding, is sufficient for this court to proceed on an action for paternity. If need be, we can have a default if he doesn't want to sign it. I don't believe he's entitled to get testing now, or at least that would be our position.
All right, so Mr. Freeman, you had an opportunity to request that testing, and you were provided with how to do that in writing. You failed to do that. You can still challenge that. I would suggest if you want to do that, that you get in touch with an attorney to help you, seek an appeal of this order or to challenge the findings of the court today. But as it stands today, there's no reason from a legal standpoint why the court can or should not enter these orders. So again, Mr. Freeman, if you want to challenge paternity at this point, I would suggest that you seek the advice of an attorney of how to do that, okay?
One other thing, Judge, if I may. For the
Yeah.
court's information, on the very same document, he also signed a second page which indicated he consented to long-arm jurisdiction of the court.
Okay, thank you. So Mr. Braylon, or Mr. Freeman, do you have any questions about that?
What he said?
Do you have any questions about how to proceed if you want to challenge paternity?
Yeah, like how I do it.
What's that?
How do I like who do I like how do I like do it, like about trying to get a DNA test?
Yeah, again, you need to consult with an attorney or do some research to find out how to do that. I can't give you advice on how to do that. I can't give you legal advice here. I'm the judge in the case, so that would be improper.
Alright.
So otherwise, for the record today, based on the statements of Ms. Stabile and the information contained within the file, as indicated by the prosecutor, the court finds it is appropriate to enter those orders. I assigned and dated those. Those are in the file, Mr. Rolla. Anything further from your side today?
No, Your Honor, thank you.
Ms. Stabile, do you have any questions at all?
No.
Thank you. That's all for today. All parties in this case are free to disconnect at this time.
Thank you.
All right, Mr. Leonardson, if you can unmute, please, and we'll go on the record in Fox versus Fox. This is case number 2219143. If I could have both counsel put your appearances on.
Mark Dundon on behalf of Carly Fox, Your Honor. She's seated in my, sorry, right here.
Your Honor, David Leonardson, I represented the plaintiff originally, but I filed with the court on July 18th of 2023 a withdrawal of counsel based on non-payment of fees by my client. I have had no contact with him since that time. I didn't check with the court, but do they have record of my withdrawal?
I don't know, Susie, if you can check that. I don't see it in the file.
I thought, you know what, Your Honor, I'm sorry, I don't mean to pipe up, but I thought I saw some motion at some point, or I could be
Yeah,
incorrect.
you signed as verified opposing counsel, Mark, but I didn't follow through. I haven't heard from anybody. I thought I was off this case.
Right, we filed an answer. Sorry, Your Honor, you're not asking me to speak yet.
Yeah, let's see what we have
Yes, sir.
on the computer first, and then let's go from there.
I will notify the court that I received that on a March 1st date from Harris Law, a answer to the complaint, which I had not received previously. But like I said, I have copies of the withdrawal and would submit them if the court would accept.
Okay.
Your Honor, we don't.
Go ahead, Susie.
We do not have anything withdrawing Mr. Leonardson from the case.
Okay, so Mr. Leonardson, if you can file that just so that we can get that entered in the computer, and then
Yes,
you'll stop receiving.
I will file it this afternoon, Your Honor.
We have no objections, Your Honor, and just if I may now, we the answer was filed late, but there's been no default. The primary issue here was custody, and Dave or Mr. Leonardson and I had shown up to try the case, and then his client, forget exactly what happened, but his client basically backed out, wanted to hire another lawyer, wanted to do something else. And so right now we're still basically waiting for him to refile something in front of the court. And it's been maybe 9 months, give or take. There are basically no assets in this case, Your Honor. So I served the defendant or plaintiff, pardon me, as well with the answer because I wasn't sure who to serve. So I guess I don't know if the court could set it out and maybe I can try to talk to him directly.
All right, so I do know for the record that plaintiff withdrew his motion for custody back in July of 2023. That's the last activity that's occurred in the file, which prompted the court to set this hearing today because there hasn't been any progress. Mr. Fox has not appeared here by video today, although Mr. Leonardson did pursuant to the notice. So I guess, Mr. Dundon, I'll set this out another 30 days, but if something doesn't happen and, you know, if your client wants to get divorced, then maybe it's going to be on you guys to move this along. But if anything happens within the next 30 days, then the court's going to dismiss it because I can't just have it sitting out here waiting for Mr. Fox to do something.
We'll file them up. The court should either, if the court doesn't ever answer, it should very quickly, and then we can get moving on trying to resolve the case or filing. You know, there's a couple different options, so we'll figure it out, Judge. My client does want to get divorced. We want this over. We'll get it sorted.
Okay. All right. So the court will set it for a status conference in 30 days, and then we'll go from there. All parties are free to disconnect. Thank you.
Thank you, Judge.
Thank you, Your Honor.
All right, Ms. Phillips Kapanki, are you able to hear me okay?
I am.
All right, do you know if your lawyer is appearing today? You
She
talked to
should
your
be.
lawyer?
Yep.
All right, Mr. Bargy, is your lawyer appearing today? Have you talked to your lawyer?
Yes, he is in another hearing right this second. I don't know exactly how it works. And he asked me to ask you to give him a few minutes.
Okay, all right, so we'll just have everybody hold for a minute here and we'll see if we can get things going in a little bit.
Thank you.
All right, Mr. Danielski, are you able to hear me okay?
Yes, Your Honor.
Okay. All right, and we've got the parties back connected. Ms. Phillips Kapanki, I don't know where your lawyer is, but I've got other hearings going, so I can't wait. We've waited 5 minutes now. This was set for 9:45, so I'm just gonna go forward here. This is set for a status conference here today, and we've got an objection to a recommended order, so I believe we need to set this for a full hearing on the objection. And so I guess what I'm looking for from the parties here today is how much time that they believe that we would need to set this for hearing. So Mr. Danielski, from your standpoint.
Well, a couple questions, Your Honor. I don't do much in Otsego. I have a cabin in Joburg, and I just did this because I said, okay, we got a trial right before Christmas. I guess I'll come up with my wife and do this. And now it's kind of extending longer than. So my concern is, Your Honor, is this going to be Zoom or is it going to be in person?
So I typically set these for in-person hearings under the court rules because it is an evidentiary hearing unless there's some kind of stipulation or the party files a motion, pursuant to the court rules to have video conferencing for some or all witnesses, but otherwise it would be set for an in-person hearing. Typically de novo hearings, I do take into account the testimony that was introduced at the hearing before the referee. I limit testimony at the de novo hearing to witnesses who didn't have time to appear or the referee didn't have time to hear from, and to new issues that have arisen since the referee hearing. So in other words, I don't take duplicate testimony, and I limit it to presentation of new evidence or new witnesses who were not able to be heard from due to time constraints.
Well, and from our side, Your Honor, I didn't have, I assume Your Honor got that huge stack of documents that I FedExed up. I didn't have time because I got involved late. He came to me and said, hey, can you do this to get those CPS reports? And I believe that's critical, that evidence, if we're going to do this, be reviewed by the court. So I don't know if I'm going to have to subpoena CPS to bring as a record keeper to bring it in, but those would certainly need to be discussed. medical records were reviewed, but I think due to time constraints, I'm not sure if they got in, so there may be some record keeping issues. So really, those are my main issues, those medical records for the oldest child. I believe the court should review those. And also those CPS reports. In terms of new stuff, I mean, yeah, I've got some new things, but I don't think that would take a tremendous amount of time. I'm usually pretty efficient in these cases. So in terms of my side, we're not talking that much time, Your Honor. I mean, I'd be if I'm introducing records and just taking some, hopefully we can stipulate to those, and then my testimony might be an hour. I mean, we're not talking much time, Your Honor. It could be 2, but it just would be touching on new issues.
All right, thank you. Ms. Doak, you're just joining in. We had to move forward with the hearing because I have other matters on the docket.
No, I'm here. I apologize. I've heard
How's that?
most of everything that's been said. I think we would need 3 hours, and I guess I would ask the court to consider limiting the other party in a certain way. The referee in this case recommended unsupervised parenting time for my client, and the other party did not file an objection to that. Then they came in and filed an answer to my objection, not granting my client custody, and now are requesting supervised parenting time. Well, they didn't object to the recommendation of unsupervised parenting time. And in fact, in the interim have allowed unsupervised parenting time. And then after they got my objection, now they refuse to give my client her unsupervised parenting time according to the FOC recommendation that they never objected to. So I would ask the court to limit them, that they're not allowed to come in and ask for something they did not object to.
Your Honor, just a couple brief comments. My client is not violating any court orders. There's always an allegation from the mother that he is, but he hasn't. The current order was supervised for a while and unsupervised. We're not violating any court orders. He's following the court orders. The second thing is there have been new events. She's been bringing the child around Cody, and those CPS reports are littered with discussions about just the mom getting, for lack of a better term, the SH kicked out of her by Mr. Cody at the home. And now she's been in the referee ordered that the children cannot be around Cody. The third thing, Your Honors, I don't know how Otsego works. As I indicated, I've only done a couple hearings up here. And I know in other counties, they'll say, look, you object, the other side objected. I'm going to look if the non-objecting party wants to bring up some issues as well. So I don't know how that works. We were going to let this go and see how it goes. That's what our thought was. But mom's already bringing the child around this Cody, who is, those reports are almost 300 pages of just violence in the home. And so those are my comments regarding that, Your Honor.
Okay, so what I'm going to do is set this for a hearing. I'm going to, I'll allow the parties to make some legal arguments. I mean, obviously this is a scheduling hearing today, so I don't have any authority one way or the other. So that's something that we can address at the beginning of the hearing. If either side wants to try to limit the other and they have a legal basis for doing so, then I'll consider that, and we'll take that into account as we go forward with the hearing on that day. I'm going to set this for a one-day hearing. If we don't need that much time, that's fine. But I think it sounds like there may be enough issues here where it'd be in the best interest of everybody to set it for a full day so that we can get things resolved on that day and we don't have to schedule another hearing after that. So it sounds like Mr. Danielski, I mean, with the records that you're going to need, if the court were to set this 60 days out, is that going to be enough time for you to be ready?
Well, I'm ready. I guess I'd like to find out if those records came straight from CPS in the hospital. I'd like to know if I have to bring in a record keeper, if we're going to stipulate to those. Otherwise, do I got to bring somebody over from Munson and bring somebody over from CPS?
There's all kinds of hearsay issues with the records, and certainly if opposing party wants to get into entering testimony that isn't under a proper hearsay objection, they would need to bring the proper witness.
Well, I think, Your Honor, that would all be preserved whether I brought a record keeper in or not. I wasn't necessarily planning on it because we've got there's probably 50 different CPS workers. I'm not gonna, my client can't afford to meet a subpoena 50 CPS workers. I was just gonna bring in record keepers and then we can deal with hearsay as needed at trial. So I'm just wondering if I have to, if counsel is gonna make me bring in record keepers, or if I can just bring the records and then we can deal with the hearsay arguments when we get there.
You can, counsel can
those are
call
two
me and we
different
can
issues.
discuss it.
All right, but there's two different issues. I mean, there's the issue of the authenticity of the records, which would require the record keeper, and then there's the issue of hearsay and whether or not hearsay within those records is admissible. So those are two separate things. Obviously, the person who maintains the files at wherever this is at isn't going to be able to testify one way or the other about the accuracy or the information contained with them. They can just say these are records that we kept that came from us. They accurately reflect whatever was reported. So, you know, those are two different issues. So I think counsel should be looking at those as two different issues here. And I agree. I think that's something that two of you can discuss. Mr. Danielski, if you don't have a stipulation and you need more time to line up those witnesses, then the court would certainly consider that. We need to move things out.
Okay, Your Honor. And
I can work with them on it. I just would need to see what the releases were and the requests that he made. So I know when I say, yeah, these records are complete, that they are. So I was provided the records, but not anything with regards to how they were obtained or what was asked for.
I can give that to counsel.
Okay. All right, so I'm going to set it for a one-day hearing. I'm going to set it for about 60 days out. I am going to ask, and I know that the parties have already filed their objection, Mr. Danielski. I know you've already filed a response to that. So I don't need any written submissions prior to the date of the hearing. Ms. Doak, I was addressing with Mr. Danielski, you know, it'll be set for an in-person hearing. To the extent that either side wants to call witnesses remotely, then they'll need to, if there isn't a stipulation to do that, then to file the proper motion under the court rule for video conferencing testimony from any witnesses that they wish to seek that way.
Thank you.
All right, Mr. Danielski, any other issues that we need to address for your side today?
No, Your Honor.
Okay, Ms. Doak. Okay, all right, thank you. The court will send out notice of the date and time of that hearing, and we'll go from there. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
One issue, Your Honor, if on the notice, if it's a date, because I have to, this probably is going to be my last hearing on this one. Yeah, I'm going to have to clear out because I have to drive up 75. It takes me at least 3 hours to get there. I do. So if there's some issue there, I assume I can contact the court. I mean, June is fairly open for me, and so is May. But that's my only worry because so I would hope that would be accommodable.
And I'm happy to work on a step to change the date if that's a problem for you. And I would expect the same because I also have a calendar as well. So.
Thank you.
Yeah.
Yeah, so any adjournments would need to be by stipulation or by motion. The court isn't going to just move it at the request of a party.
Thank you.
Okay, all right, thank you.
Thank you, Your Honor.
All right, sir, you're Dennis Smith, is that correct?
Correct.
All right, we're on the record in Smith versus Bidwell. This is case number 1817430. The record should reflect that Mr. Smith is present today by Zoom. And then, ma'am, are you Lisa Bidwell?
Yes.
Okay, and Ms. Bidwell is also present by Zoom. This is case number again, 1817430. Mr. Smith, you filed this motion here today for hearing, indicating that there's been a problem getting the order that the court issued back in last July for genetic testing. Is that correct?
I'm sorry, I didn't understand.
I have here a document filed by you, Mr. Smith, that says I'm requesting a motion to have lab work for paternity testing to be enforced and completed as ordered by Judge Mertz.
Yes,
You set that for hearing today.
yes.
So what's the problem? What's going on?
Problem is we had 60 days to get this test done. It has now been 115 and the test is still not done.
Okay, why hasn't it been done yet?
I am not sure. Mine is done and complete. It's been complete since December 29th.
Your Honor, I never received anything about it. I even tried to contact Mr. Smith and ask him what's going on with the paternity test because I have no question in my mind that they're his children. And I got no reply. I seen he read my message and did not bother to reply. I think he just doesn't want to pay for the testing. I don't know how that works, but
So Mr. Smith, you're saying you got your half done, but the testing hasn't been done for the two children. Is that right?
Correct.
All right. And Mr. Smith, you're aware that you have to pay for that, correct?
Correct. It is already paid for.
and I had no idea. I was told not one thing about it. I got nothing in the mail, no text, no nothing. I even, like I said, I asked him, I was like, what is going on with testing? Because what do I have to do? I'm trying to go through with this and I got nothing, no response.
All right, so Mr. Smith, whatever facility you went through, you need to set up an appointment to have the kids tested and then notify Miss Bidwell, and she's required to make them available and bring them and to get that taken care of.
So it'd be my responsibility to set the date and time for her.
Yeah, you're the one who's asking for the test, so yeah.
As far as I knew, all I had to do was pay for it, and she was responsible for setting up her own dates. That is according to the judge, that she was responsible for doing that herself.
It doesn't say she's responsible for doing that herself. It says she has to cooperate and make children available for it. So you need to set it up, and then it's her responsibility to make sure the kids are there and that the testing is done. But she needs to know when that is. She can't just make it up in her own mind about when she's supposed to do this. You need to get it set up.
No,
and let her know.
I figured she would be the one to make the calls and set this up on her schedule.
You're the one who's asking for the test. You need to set it up. You need to notify her. And then if she doesn't do it, then you've got an argument that there's a problem.
Okay.
All right.
Okay.
Okay. Ms. Bidwell, did you have any questions?
I do. I was gonna fill out paperwork about something else in the matter. Can I bring that up now while we're here?
No, I'm not going to start going into issues that aren't set for today. So if you have other issues, then you need to file that separately.
Okay, that's fair.
Okay.
Okay.
All right. Thank you. That's all for today. Both
Right,
parties are
thank
free to
you.
discuss. Okay, if I could have you both unmute, please. Okay, we're on the record now in Morrison versus Morrison. This is case number 2319363. The record should reflect that both parties are present today by Zoom video. I have this set for a final hearing today. I'm also in receipt of the closing documents that were submitted by the parties. Ms. Morrison, did you want to proceed with finalizing the divorce today?
Yes, please, Your Honor.
And Mr. Morrison, is that how you want to proceed as well?
Yes, that works. Yes, Your Honor.
Okay, if you could both raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes, Your Honor.
Thank you. You can lower your hands. I'm going to ask both of you some questions. The questions that I'm going to be asking you are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. And so, Ms. Morrison, as the filing party, you filed for divorce in this case and you signed those documents. Is that correct?
Yes, Your Honor.
At the time that you filed for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes, Your Honor.
Had you been a resident of Otsego County for at least 10 days?
Yes, as of right now, I guess I'm in Montmorency County. But
Okay, at the time that you filed the divorce, were you in Otsego County for at least?
yes,
10
Your
days?
Honor.
Okay. In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes, Your Honor.
Does that remain true today?
Yes, Your Honor.
Okay, and there was one child born of the marriage, is that correct?
Yes, Your Honor.
That child is still a minor, under 18?
Yes, Your Honor.
And the judgment of divorce would provide that you and Mr. Morrison would share joint legal and physical custody of your child, and that essentially you would split it right down the middle. Each of you would have half 50-50 custody. Is that correct?
Yes, Your Honor.
And as a mother of your child, do you agree that that would be in her best interest?
Yes, Your Honor.
Okay. As part of the divorce, oh, I'm sorry, are you currently pregnant?
Yes, Your Honor.
You are. Is that correct?
Yes, Your Honor. Different father.
All right, well, we're gonna have a look, we're not gonna be able to finalize the divorce today because any conception of a child during the time of marriage is presumed to be of the marriage. And that's why we asked that question at this time before we grant the divorce. So what you're gonna need to do, I'm gonna have to refer this back to the friend of the court. There's gonna need to be a paternity test done or an acknowledgement of paternity by whoever the father is, so that we can establish that it's not Mr. Morrison before I can grant you the divorce.
Is there any way, I do have the father sitting with me. Is there any way that I can have him step forward now and vouch for the child?
Yeah, we can't just do that off the cuff like this. There needs to be paperwork filled out and there's a procedure that has to be followed.
Okay, Your Honor, thank you.
So I'm gonna refer this back. Ms. Kraus, are you there? Thank
Yes,
you.
Your Honor.
How do you want them to handle this? Can I have them, do you want Ms. Morrison to give you a call for how to proceed further?
Yes, that would be great.
All right, so Ms. Morrison, you're gonna need to call the friend of the court and contact them to set up some further proceedings to get that part of it taken care of. And Mr. Morrison, you're free to contact the friend of the court too, so that you can be apprised of where things stand with regard to that, okay?
Okay, thank you, Your Honor.
All right, Ms. Morrison, do you have any other questions at this time?
No, I guess not, Your Honor. No.
Mr. Morrison, did you have any questions?
No, Your Honor.
Okay, all right, thank you. Both of you are free to disconnect. And again, Ms. Morrison, contact with friend of the court as soon as possible. Okay, Mr. and Miss Wilkinson, if I could have you both unmute yourselves, please. Thank you. We're on the record in Wilkinson versus Wilkinson. This is case number 2319416. The record should reflect that both parties are present by Zoom video here today. Have this set for entry of a final judgment of divorce, and I do have the documents that were submitted by the parties. Mr. Wilkinson, did you want to proceed with finalizing the divorce today?
Yes, sir.
All right, and Ms. Wilkinson, is that how you wanted to proceed as well?
Yes.
Okay, if I could have you both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can lower your hands. I'm going to ask both of you some questions. The questions I'm going to be asking are the questions I'm required to ask in order to establish the grounds for divorce under Michigan law. And Mr. Wilkinson, you filed for divorce in this case, is that correct?
Yes.
At the time that you filed for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you filed the complaint?
Yes.
Does that remain true today?
Yes.
And there's one minor child that was born of the marriage, is that correct?
Yes.
And under the judgment of divorce, you and Ms. Wilkinson would share joint physical and legal custody of your child. And in essence, you would have equal number of overnights, so 50-50 parenting time with your child. Is that correct?
Yes.
As the father of your child, do you agree that that arrangement would be in your child's best interest?
Yes.
As part of the judgment of divorce, Mr. Wilkinson, you would not be receiving any alimony or spousal support. Do you understand that?
Yes.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
And from your standpoint, there are no issues regarding the division of any assets or debts of the marriage, is that correct?
Correct.
Do you own any real property or real estate with Ms. Wilkinson?
No.
Okay, thank you. Ms. Wilkinson, have you heard all the questions that I asked Mr. Wilkinson?
Can you repeat that? Sorry.
Sure. Have you heard all the questions that I asked Mr. Wilkinson?
Yes.
And did you hear all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were not true?
No, I do not.
And are you currently pregnant?
No, I'm not.
And do you agree with the custody and parenting time arrangement? In other words, that you would share joint physical and legal custody of your child and that you would each have an equal amount of time with your child?
Yes.
And as the mother, do you agree that that would be in the best interest of your child?
Yes.
You also will not be receiving any alimony or spousal support. You understand that you would also be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
And do you agree that all issues regarding the division of any assets or debts of the marriage have been resolved?
Yes.
and that you do not own any real estate or real property with Mr. Wilkinson.
No, we do not.
Okay. All right, thank you. The court finds, based on the testimony of both parties, that the statutory grounds for divorce have been met. The court will grant the divorce, and I'm signing that judgment along with the child support addendum. And that's available for either of you if you want that for your records here at the courthouse. And Ms. Wilkinson, are you asking to have your last name changed?
No.
Okay. All right, thank you. So your divorce is final as of today. Again, I've signed the closing documents. Mr. Wilkinson, do you have any questions at all?
No.
Ms. Wilkinson, do you have any questions?
No, I do not.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Thank you.
Okay, it looks like we have everybody connected, so we'll go on the record now in Tabaka versus Tabaka. This is case number 22-19040. We have Ms. Tabaka connected with Mr. Dundon, her counsel, and Mr. Tabaka, if you could unmute, quick, thanks. Mr. Tabaka, do you have counsel that's going to be appearing today?
Yes,
You do. Is it Mr. Leonardson?
correct.
Okay.
Your Honor, I spoke. Sorry, I spoke
go
to
ahead.
I spoke to Mr. Leonardson this morning on my way in. I believe he's going to be here. There was we served Mr. Tabaka and Mr. Leonardson just because, as the court's aware, the judgment looks like it discharged Mr. Leonardson in 21 days. So I wasn't sure who to serve, and I didn't hear back. But this morning, Mr. Leonardson called, so that's where we are as far as that, Judge.
All right, I don't see him yet, so let's just all stay on hold here for a couple minutes and we'll see if he signs in.
Yes, sir.
All right, just reconnected with everybody. I'm gonna need to move forward, because I've got other hearings coming up. I guess I want to get a sense of whether we need to reschedule this when Mr. Leonardson can appear. I don't know, Mr. Tabaka, did you have a chance to look at the motion? Is there anything you wanted to say at this point, or?
Yeah, I'm okay to move without Mr. Leonardson here, if that's allowed.
Okay. Yeah, that is totally up to you. One thing, I guess, the first thing is the addition of the communication through the third party app. Mr. Tabaka, do you have any objection to adding that into the judgment of divorce?
I do. I don't see the need for it.
All right,
That was
Mr. All right, Mr. Dunnan, I looked at your motion and then you have the judgment of divorce in there. I don't know if there was a written mediation agreement. I mean, do we have some evidence that this was something that was part of the mediation?
There is, Your Honor. I apologize. I think I submitted it with another motion, but it's absolutely in here. It's Friday, December 16th, 2022. The written mediation agreement says both parties also agree to utilize a family communication tool application for communication between them, unless in the case of an emergency whereby a phone call would be appropriate. This will alleviate the children being part of the parental communication loop. To be honest, I've never seen, I think those, first off, it is, again, I understand the court, maybe, I apologize, the court doesn't have a copy of it. The box is checked that it was sent to you, Your Honor, but obviously I'm not expecting you to scramble. But as an officer of the court, I'm definitely reading it. I was here for the mediation. It is indeed in there. So again, we would argue it's enforceable, and I don't see an effective argument against it. It works like texting, as you know, and then it just shows who got what when. And if there's an emergency, they could still communicate via phone.
All right, so Mr. Tabaka and Mr. Dunnan, for both of you, I am looking at, I do have a copy of it. It was in the file as part of a different filing. But it's a mediation agreement dated December 16th, and that does indicate that. So, I mean, Mr. Tabaka, this is the kind of thing where, you know, there may be a legal argument for not enforcing that. And that's something, I guess, that maybe if you're objecting to it, you may want to have Mr. Dunnan or Mr. Leonardson formulate an argument on your behalf, because generally, you know, it would be legally enforceable. So,
Okay, I guess I was under the impression that was under the previous mediation agreement. It wasn't in the decree. That's what I was going off of. And in the decree, I have it where all temporary orders are removed, and I thought that was a temporary order.
all right, so I mean, I don't know. Mr. Dunnan, I guess in all fairness, Mr. Tabaka has a lawyer. This is the kind of thing that requires a legal argument to have that part not enforced if he's objecting to it.
That's okay. We can table this if the court's all right with it. Again, I just to reiterate though, Your Honor, I would, you know, we cited the court rule. It is enforceable. This, you know, this is we would argue it's a clerical error. It was meant to be in there, but that's fair if he wants to talk to Dave, sure.
Yeah, so I think what I guess what I'm going to ask Mr. Dunnan is I'm going to ask you to renotice this, and the court will take it up and give Mr. Tabaka a chance to have Mr. Leonardson present. Mr. Tabaka, if Mr. Leonardson's not present at that next hearing, then we're going to have to move forward one way or the other. Okay.
I understand that.
All right, but I think in the interest of justice, I think the court has to give Mr. Tabaka an opportunity to have counsel present arguments on his behalf.
Okay, again, I guess I'm just concerned that my client is not, you know, getting the money that's clearly spelled out in the judgment, Your Honor. But if the court's inclined to adjourn until Mr. Leonardson can be here, it is what it is. I just, my client has been waiting, you know, again, it's pretty clear, if I can just briefly state, you know, the 400 per month starting December 1st, and then the 1150 for the back pay is pretty clear. The months are rolling and my client hasn't gotten anything. We also submitted the uniform spousal support order, which would at least clarify stuff going forward, Your Honor. But thank you, Judge. I just wanted to make a brief statement.
Yeah, and I mean, Mr. Dundon, if your client is incurring extra costs or, you know, is suffering some kind of financial harm and it's determined that the payments should have been made, then, you know, that's something that you can ask for to make up for that as well.
No, we did.
I'm okay to move along with the rest of it without Mr. Leonardson present.
Okay.
Yeah.
So then, Mr. Tabaka, what's going on with the payments?
So basically what I had told before the final judgment hearing, which I was told I didn't need to be a part of that hearing, I was told that, and I talked this over with Mr. Leonardson, that that I was not going to be making direct payments to her, and it would come out of my paycheck at $100 a week. And I had no problem with that part. And that didn't end up there in the decree. There was nothing about how I was going to make the payment. And so I have no problem making those payments. And I even went to the court to try to set that up. And they sent me to the friend of the court. Friend of the court sent me back to the court saying I need to be in front of a judge in order to make that happen now. So I have no problem having those payments taken out at $100 a week out of my check.
Wait, Your Honor, we're not, the judgment's enforceable regardless of the mechanism. And we did submit, you know, on 12/12, we signed the a uniform spousal support order, which said, you know, effective 12/1/2023, $400 a month. I'm not acute. Maybe this didn't get through to Mr. Tabaka, so I'm not exactly sure, but we have attempted to do it. So again, and our perspective based on the judgment is there is nothing here that says $100 a month. It says $100 a week. It says 400 per month payable on the first starting December 1st. And then there's a back payment of $1150 due within 90 days, which I believe would be, March 14th, I believe the $1150 would be due. So we would just ask the court to enforce the judgment. If Mr. Tabaka wants to sign, if he hasn't, again, I'm not saying if there was a miscommunication and he didn't get this from Dave, we did submit a uniform spousal support order. So going forward, we're fine with using that, but our position is my client is owed the money she's owed per the judgment, Your Honor.
Which is how much at this point?
It would be, 400 so December, January, February, March, that's 1,600. And then the 1150 in back pay is due 90 days from the date of the judgment, which is December 19th. No, sorry, Judge, my copy's a little bad. I believe the court signed it December 14th and the true copy was December 19th. So 90 days from that day, the 1150 would be due. If it's the 14th.
And none of those payments have been made?
No, Your Honor.
Correct.
All right, so Mr. Tabaka, I mean, I get that you want to have this set up in a certain way, but you can't just not pay while you're getting that set up. I mean, you still owe that money. You're going to need to pay that money immediately.
I understand that. Like I said, it's just about, so I've gotten screwed in the past in giving her money directly. So that's why I just didn't want to give her anything directly. I wanted it to go just taken out.
Your Honor, if I may.
That's fine, but while you're setting that up, you know, and while you could have been making those payments, send it to Mr. Dundon if you don't want to send it to her directly so that you've got a third party, you know, that can account for it. I mean, you can't just not make the payments while you're figuring out how the mechanism is gonna be to make the payments.
Your Honor, I would just take exception, as the court saw in our last motion, we itemized every dime that she was given in our last motion. And again, if money's pretty easy to track unless he's gonna say he's been giving her cash, which I don't, if he gives her, you know, a $400 check, he'd have a pretty easy time telling the court he gave her $400, Judge.
All right.
She
Ms.
hasn't
Strauss, was there
received.
something?
Sorry.
Ms. Strauss, is there something you wanted to add?
Yeah, I guess what my question would be is there needs to be a little bit of clarification in regards to the spousal support, because yes, the party has stopped into us. Front of the court had not received anything in regards to the spousal support. So our understanding is that the spousal support is not being collected through front of the court.
Yes, Your Honor, and the front of the court's not wrong. We've been trying to get this signed and then we could submit it, but again, it has not, we sent it out in December and it hasn't been signed. But again, I believe that, I'm not overstepping my bounds here, but I believe the proper thing to do would be to maybe agree to executing this order. It goes through front of the court, starting maybe April 1st or as soon as it could, but then the back pay, which as of March 14th will be $31.50. You know, we would request that the court order the $31.50 to be paid by March 14th. And then we can, if Mr. Tabaka will sign this, I will get it over straight away to the front of the court.
All right, so Mr. Tabaka, you want this to go through front of the court going forward, correct?
Correct.
Okay. All right, so I think we're on the same page. So Mr. Dundon, if you can communicate with friend of the court about getting the paperwork set to have that begin in April.
Will do.
And then Mr. Tabaka, you're gonna need to make that back payment of the money that's owed, and you can, Mr. Dundon, do you have any objection to him submitting that check to you so that he can get a receipt and have it verified that he made the payment?
None whatsoever, Your Honor, that's fine.
Okay, so Mr. Tabaka, do you have any objection to that? That way you've got proof that you'll have written proof that you submitted the payment?
No, I have no, and that's fine.
Okay, all right,
And
that
that,
sounds reasonable.
Yeah, just want to get clarify on that number. It was 3150 by the 14th of March. Is that correct? Mark?
That's what we would request based on the judgment. Yes, I'm not speaking for the judge though.
No, I think that's right. That's the correct amount.
And then that would include the 1100 or the 1150 payment.
That's correct.
Right.
Okay. Yep.
Yeah, and then we'd be starting from ground zero in April.
Correct. Yep, that's fine. All right,
Thank
and
you.
then I have another issue that Mr. Leonardson was gonna bring up. She had 14 days from judgment to get me off of her vehicle that we have leased together. So I need to, and she hasn't done that. So that needs to happen too.
Okay.
You get it.
So let's set that for hearing along with the issue about the third-party app. And
Okay.
then Mr. Dundon, take a look at that and discuss that with your client, and you can make an argument at that hearing as when we address that.
Will do, Your Honor.
And Mr. Dundon, I'm going to ask that your office just renotice that hearing, okay?
Yes, sir.
Okay.
Also, and then one more, there was one other issue too. So I have, I had paid, for child support arrearages. I was paying before they were coming, before the friend of the court started taking them out, and I've submitted proof of payment to the friend of the court. And then that was supposed to be calculated in the judgment, and it never was. So they just sent me something saying I owe it again.
Your Honor, if I mean, we don't have a dog in the fight here. I mean, if he's, again, as we made clear in our first motion to enforce the mediation agreement, we're not going to dispute any money Mr. Tabak has paid. He's paid. We're not arguing
I guess yeah, I'm sorry, go ahead.
No, that's it for us.
I guess I just wanted to get it on the record for the friend of the court because they're not, I submitted proof and then they sent me something saying it would be handled at judgment and it never was. So now they're needing more, I guess. Saying that was paid.
All right, Ms. Kraus, is that something that you need to take a closer look at, or?
There was information that was sent to Mr. Tabaka in regards to the amount that is still due. So if the other party is indicating that that money was received.
I'm not sure. We would have to double check, but I know in the motion I filed a few months back, we did itemize. My client and I sat down and itemized all the money that she received.
And at that time it was correct. It's just friend of the court never got it somehow, or they never got proof of that.
Well, again, we'll work, Your Honor. I don't know if we can. I know the court has other. If any dime Mr. Tabaka has paid, if it is what it is. We will. If there's somehow a glitch that we can help fix, we'll do it.
Okay, so I guess Mr. Tabaka, this is something that you're gonna have to handle by phone call with Mr. Dundon, and maybe the two of you can agree on what's been paid and then notify the friend of the court, because they'll adjust that. And yeah, I mean, there's no reason why anybody should pay double for something that they've already paid for, and there should be enough records between the three to know what's been paid and what hasn't. It just might need to be straightened out. So okay. That's something that you guys should deal with, I think, off the record.
Yes, sir.
Okay, we can do that. And then also going back to the Family Wizard app, I don't need to object to that. I just thought I thought I didn't have to, but if it is part of the latest thing we signed, I can go ahead and start using that.
Thank you.
Okay. So,
I'll get.
Why don't you add that into the judgment then?
Yes, sir.
Yeah. Yep, that's fine. If it's added in there, I don't need to fight on that. I can use that. So my only thing now would just be getting my name taken off the Explorer.
I'll talk with Mr. Tobias. I'll get with you, Ken, if Mr. Leonardson isn't available, and we can see what we can do about this anyway.
Okay.
Your Honor.
Yeah.
Just for clarification, Mr. Dundon and Mr. Tabaka are going to discuss the amounts that have been paid between the parties, and then Mr. Dundon can submit something to friend of the court in regards to the amount based on the letter that was sent that we would forgive.
I'm okay. I'm all right with that, Your Honor. If again, what's been paid has been paid, so we'll take care of it.
Okay,
Yeah, I
I'll
think
wait
that's
to hear from you.
I think that's a good way to do it.
Yes, sir.
Okay. All right, so the court's not going to set anything for further hearing. Mr. Tabaka, if you need to proceed on the issue regarding the vehicle, then just get with Mr. Leonardson and he'll file something for you, and we'll get that set for hearing. Okay.
Thank
Okay.
you, Judge.
Thank you.
Okay, thank you. That's all for today, and all parties on this case are free to disconnect at this time.
Thank you, Your Honor.
All right, we have Mr. Jones connected. We're on the record in Jones versus Jones, case number 1917709. This was set for hearing at 10:45. It's now almost 11 o'clock. Ms. Jones has not appeared. This was set as a follow-up hearing to a motion by Ms. Jones to enforce the judgment of divorce. Since she's failed to appear today, the court is not going to proceed any further, and it will dismiss her motion. So Mr. Jones, there's nothing that you need to do for today or going forward as of now. Do you have any questions about that?
Nope.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
All right, Mr. Hildebrand, if you can unmute, please. Thank you. We're on the record now in Chelsea Brink versus Devin Hildebrand, case number 11145050. The record should reflect Mr. Hildebrand's present today by Zoom video. Mr. Hildebrand, have been represented in the past in this case. Are you appearing on your own today, or do you have a lawyer that's going to be appearing for you?
I'll be on my own today.
Okay, and this is your motion regarding parenting time, and you're asking the court to change or eliminate Ms. Brink's supervised parenting time, is that correct?
Yes, sir.
Okay, and I know you put this in writing along with your motion, but can you just make a statement of why you believe that's appropriate at this time?
Well, given the most recent visits over the last couple of months, there has only been probably maybe 2 productive ones out of the last probably dozen. And everything else has been either cut short by me or my wife, whoever is supervising at the time, just for inappropriate contact. For example, there's one time that I put in my motion there where she went off about getting her earring ripped out and then proceeds to tell my daughter that this happened while we were screwing. And my daughter was like, all right, that's enough, Mom, and hung up the phone. And just the visits are more detrimental to my daughter than they are productive for the relationship between the 2 of them. My daughter, she worries about her mom. She hopes she's okay. But at the same time, it throws her emotionally into a loop of, kind of depression and that stuff if I have to continue doing these. And I don't really want to be held into a court order to subject my daughter to that. If we could put it back to at one point it was as parties agreed, where I wasn't bound into making a weekly visit and setting my daughter into this, setting her up for that. I don't want to completely eliminate contact. If my daughter wants to call her, if Lila wants to call her, I'll let her. I do it even if it's not a scheduled visit day. But I don't want to be forced to continue doing that.
Okay, understood. All right, I had a chance to review the written motion prior to the hearing today. I've heard from Mr. Hildebrand on the record. Ms. Brink did not file anything in response to the motion. Motion was set for hearing at 11:15. It's now 11:23 by my clock, and Ms. Brink has not appeared. I don't see her in the Zoom waiting room to contest the motion. So what I'm going to do, Mr. Hildebrand, for purposes of today's hearing, the court's going to issue a temporary order suspending the parenting time. And then I'm going to set this for a short hearing. I'm going to set it for an hour. I doubt we'll need that much time, but I'll need to take some testimony from you regarding the circumstances. And then how old is it Lila? Is that your child? Yeah. How old is she now?
She's 13.
Okay. And so I'm going to need to, and this may have occurred before, where the referees had an interview with her. And so I'm going to need to do that so that I can talk to her a little bit. She's at an age now where I think she can express what she would like to see happen and get her view on what's been going on. And then once I have those 2 things, then I can make a record, because as you're probably aware through the course of the proceedings, anytime the court changes parenting time or makes permanent adjustments, I have to make findings for the record that it's in the best interests. And I need to have a basis to do that. And between your testimony and what she has to say, and Ms. Brink will have an opportunity to appear for that hearing and tell me what she wants to tell me as well. And then the court can make findings. So, but I think it's appropriate at this point to suspend it based on what you presented to the court so far until we can have that hearing, so that you don't, as you indicated, have to force your child to have those phone calls for the time being until the court can make those permanent findings. Do you have any questions, or do you understand how we're gonna go forward.
Yeah, I understand how we're gonna go forward on this. I do have some like screen recordings. What is the best way to, would I have to put those on like a USB thumb drive of prior visits, like of my examples? I have some examples on like their videos, but how would I present them to the court? What is the best way to do that?
Yep, if you can put those on a thumb drive or a flash drive, and then it would be helpful. We'll send out notice of the date of that hearing, but it would be helpful if you can submit that before the hearing so that I can review those.
Yes, sir.
Okay, and then in terms of a schedule of having Lila come in, I can set this at a time that's convenient for her school schedule. Is there a time that would be best, that would make it the least obtrusive for her?
Yeah, she gets out of school around 3. If we could do it sometime between 3 and 5, that would probably work for the both of us.
All right, so if I set it for a 3:30 hearing.
If we could do closer to 4, that'd give me a little bit more time to get from Joburg to Gaylord.
Okay. So the court will set it for 4 o'clock. I don't have the date yet, but I'll set it for later in the afternoon, and then we'll send out the date of that hearing along with the confirmation of the time.
Yes, sir.
And then I'm going to issue a written order today, suspending the parenting time. That'll go to the friend of the court, and so you can get a copy of that as well.
Okay.
All right. Any other questions for today?
No, sir.
Okay, thank you. You're free to disconnect at this time.
Alrighty, thank you.
Okay, looks like we have everybody connected. We'll go on the record in Moriarty versus Moriarty. This is case number 2319411. If I could have both counsel put your appearances on, starting with plaintiff.
Good morning, Your Honor. Jennifer Dutzman Coy on behalf of Barbara Moriarty, who is present with me in my office.
David Grunst on behalf of John Moriarty and the conservators. Andrew
Okay.
Moriarty and Marie Walker.
All right, Mr. Grunts, were you anticipating any of your clients appearing today?
No, Your Honor. I think Ms. Walker might appear, but she had at 11:45, so I don't know if she's going to be here or not.
Okay, I'm not seeing anybody else in the waiting room, so let's go forward. The court set this for a status conference today based on a filing requesting to reopen the case and proceed. And Ms. Dutzman-Coy, on behalf of plaintiff, can you tell me where things are at from your standpoint and what you would like to see going forward here so that we can move towards a resolution?
Sure, Judge. We had asked the court to place an administrative stay on this matter. Mr. Moriarty was hospitalized, I think, back in September or October, and the court had placed that stay while we determined what was going on with him. Since then, there has been a guardianship and conservatorship established for him by Judge Cooper in this county. So Mr. Grunst represents the guardians and the conservators. And so at this point, we feel it's appropriate and frankly necessary to go forward with the divorce portion now that we have that guardian and conservator established. There's a bunch of different assets in this matter that need to be dealt with that the probate court frankly can't really deal with. So we're asking to move forward on the divorce now.
Okay, and what are you asking for in terms of an order today for scheduling?
Well, I think we need to have some additional discovery. We've exchanged some documents, but I'd like to have some time to, be able to do a little bit more discovery. I have sent out a couple of subpoenas to some financial institutions, so I'll need some time for them to respond and to deal with that. So I do think that we need some time for discovery. Mr. Grunst probably wants some things from us as well. And so I think probably 60 to 90 days of discovery would be appropriate. And then I don't know if we would need to have another status conference at that point. We might be able to settle things. We did have mediation actually last week on the guardianship and conservatorship where we were able to settle some things. And I wouldn't mind being referred back to mediation again, but that would maybe be after we've had the chance to conduct that additional discovery.
All right, thank you. Mr. Grunst?
Yes, thank you. The guardianships are only temporary. We have a hearing tomorrow to extend those till April 15th, where we can have a hearing, I believe, between tomorrow and April 15th to finalize the temporary guardians and make them full guardians. The conservators are in place. I would note that even though there's a stay in place, Ms. Coy is sending out subpoenas contrary to the court stay to various financial institutions under this case requesting discovery even before this motion was filed. So I don't know why that's happening. I thought a stay is a stay. You don't do anything while the stay is going on. Ms. Coy has decided that she wants to send out subpoenas contrary to what the state provisions are. But as far as going forward, Judge, I'm presently on vacation for the rest of the month. And so I'm not going to be able to conduct any discovery probably until I get back, which would be April 1st. So I'd ask for about 120 days of discovery and then send it to mediation possibly after that. After we have maybe a final settlement conference. I think after we get all the numbers put together, I mean, I think it's simply a numbers game and who owns what. Maybe there needs to be some decisions from the court as to what's separate property versus marital property. I will need to file an objection to the temporary restraining order that allows Ms. Coy's client to be in the house without having to pay any bills. She puts that on my client, and my client presently is even though he's out of the VA hospital, he is in a nursing home, and the price on that has been determined to be somewhere between $14,000 and $18,000 a month. It's going to deplete his assets fairly quickly, and yet Ms. Coy wants Mr. Moriarty to pay her client's bills to the house, and that's the cell phones, the utilities, and the insurance. And I think that needs to come out of marital funds, not just my client's funds. And so I'm going to be asking the court to either set that aside or modify it.
All right. Here's what I'd like to do. It sounds like there's some issues that are going to need to be worked out, certainly. I think what I'd like to do is have discovery remain open for the next 90 days and then set it for a status conference at that point. Let's see if there's further discovery that needs to be done, or whether the parties have enough to have another mediation. Mr. Grunst, you're free to file, any of those kind of motions at any time and notice those for a hearing, and the court will take those up as those are filed. But in terms of just scheduling going forward, I think 90 days for discovery with a status conference at the end of that. And then again, the court can look at ordering mediation. You can see what kind of progress the parties have made and go from there. Ms. Stutzman-Coy, do you have any objection to that?
None, Your Honor. Thank you.
All right. Mr. Grunst, do you have any objection to that?
I'm fine, Your Honor. Thank you.
Oh, all right. So I'll put that into a scheduling order. I mean, Ms. Stutzman-Coy, maybe you jumped the gun a little bit on sending out those subpoenas, but I don't know that there's any. There's not really a request for sanctions, and it looks like those were just issued relatively recently. So to the extent that those were sent out early prior to the hearing today, the court doesn't find that there's grounds for any kind of sanction at this time. So the court's not going to take action on that as a procedural matter. And then the court will send out notice of the date and time for that next hearing in about 90 days, and that'll be by Zoom. Ms. Stutzman-Coy, anything else that I can address for your side here today?
And not today, Your Honor. Thank you.
Mr. Grunst?
No, Your Honor. Thank you.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time.
Thank you, Your Honor.
Thank you. Have a great day.
Thank you. All right, looks like we have both counsel connected. We'll go on the record in Strong versus Breed, case number 2319402. And if I could have counsel put your appearances on, starting with plaintiff, please.
Keith Serlin for plaintiff, Your Honor.
Elliot Blumberg on behalf of the defendants, Your Honor.
Okay, this is set for a status conference today, just to see where things are at. I know there's been an issue regarding the mediator in this case. So as to that, and just Mr. Blumberg, and I know you have a motion set for April 1st regarding discovery. But in terms of the mediator and scheduling going forward, Mr. Blumberg, what's your input today?
Judge, Mr. Serlin's been out of commission for most of the winter. He's been in Florida, I believe. So I had suggested we use Jerry Sheffalo for mediation. I never heard from him. And so because we couldn't come to an agreement, somebody else was appointed by the mediation clerk. At first, I kind of objected to that, but it doesn't matter at this point. Today, 7 months after the filing of this lawsuit, we finally got plaintiff's initial disclosures. He's not answered any of the interrogatories or requests for admissions. So this case isn't ready to go to mediation because frankly, the plaintiff has done nothing to move this case along. So I don't mean to be rude, but that's the reality of the case today.
All right, thank you. Mr. Serlin?
Well, you're not being rude, Elliot. You're just plain wrong. We submitted answers to your request for admissions and interrogatories,
When?
so. And I don't know why you don't have them, but we sent them to the court and to you. So we have framed the issue. I indicated to you on the phone two things. One, I had no problem with whatever mediator you wanted, and I made it that clear to you. Just do whatever is necessary to get the fella who you wanted. I had no problem with that, and you know that. So if there was any confusion or mix-up, it was not on my part, period. Now, I don't know why you filed the motion with respect to dismissing the claim based on the not answering your discovery, because we did. And I know the court probably has it in their file and you have it in yours. So
Believe me, if I had it, I wouldn't have filed the motion.
well, then, you pick up the phone and, you call. I'm old fashioned. I talk to people on the phone. And yes, I was out of the country. And yes, I've been in Florida. Right now I'm in my office and I can do anything to accommodate anything that needs to be done. I don't obfuscate cases. I don't run. I don't hide. I'm out there. I'm old fashioned. I'm 71 years old. Been around the block. So I'm more than happy to talk to you, anybody else, anytime, anywhere. As far as email, no, I always don't get it. I'm semi-retired. You know that. I understand that you know that. So please don't say that I'm, out there somewhere, nowhere to be found, because I'm not. I can always be found. I have an office. You can call my secretary 5 days a week. So I agree with you. The case is not ready for mediation, but whoever you want as a mediator is fine with me. It doesn't matter to me. I'm sure you're an honest person, and whoever you pick would be fair and honest as well. So that's it.
The problem is that unless we both agree to somebody, and the mediation clerk has the obligation to pick somebody that she picked from the list.
Yeah.
Doesn't matter. I mean, but I guess the bottom line is, Judge, we're not ready to mediate the case. I apologize. You asked me that question 10 minutes ago and I didn't answer it.
All right, so right now, I believe Mr. Wims has been selected, and do either of you have any objection to Robert Wims being the mediator?
I mean, I don't even know who the guy is, so, I mean, I don't know.
I talked about the phone. He seemed like a very affable, nice person. I don't have any problem with him. I don't know the man. I assume if the court, he was on your list, Judge, I assume he's a fair person. Right?
Oh. So I'm not hearing any specific objections to Mr. Wims. We'll have Mr. Wims remain as the mediator. I'm going to give the parties an additional 90 days. I do see that on January 16th, there are some answers to interrogatories and request admissions that were filed with the court by plaintiff. So those are out there, and so I don't know if that encompasses any or all of your motion that's set for April, Mr. Bloomberg, and I'm not sure why you wouldn't have received those. So
Judge, I think you know me well enough that if I received them, I wouldn't have filed the motion.
Yeah, so I'm just saying they're in the file, so I don't know.
Well, prior to filing the motion, we have a requirement that we contact the other attorney and ask what's going on.
Not for requests for admissions. After 28 days, they're deemed admitted. That was the
No. There's a court rule that says that before you file a motion, you have to get concurrence from the other side. If you would have called me, I would have said, hey, Elliot, I got them. I'll send them to you. You didn't have to file the motion. That's the whole idea of that court rule asking for concurrence. You never called me. You never contacted me.
All right, let's not argue the point, okay? Perhaps you can send me another copy then, if you would be so kind.
Absolutely, yes. Today, yes.
Okay. All right, so let's take 90 days for further discovery. The court's going to set it for a status conference at that point. The court's going to order that mediation with Mr. Wims occur within I misspoke, I'm sorry. Discovery for another 90 days. The court's going to set this for a status conference at about 120 days. And the court's going to order that mediation occur with Mr. Wims within that 120-day period. Mr. Blumberg, or Mr. Serlin, if you can send another copy to Mr. Blumberg of your answers. Mr. Blumberg, take a look at those, make a determination. We have the motion to compel set, so we can go forward with that if we need to. If you guys are able to resolve that ahead of time, just let the court know and we can take that off the docket. And then we'll go from there. Mr. Blumberg, is there any other scheduling matters that I can address from your side today?
No, Judge, thank you.
Mr. Serlin.
No, Judge, thank you for your patience. I appreciate it.
Okay, thank you. I'll put that into an order and get that out to the parties along with the notice of date and time for that next status conference, and both sides are free to disconnect.
Thank you, Judge. By the way, Judge, you still there?
Yes.
I talked to your clerks several times on the phone. They're very kind, very helpful. I want you to know I appreciate that.
Thank you. I appreciate that, and I will let them know for sure.
Thank you, Judge. Take care.
All right, that concludes our morning docket. The court will be in recess.